Hola.
Hi, how are you?
Fine. How are you?
I am good. Thank you. I've got a payment link for us, but I think you don't see the chat from before you joined. So I'm gonna wait for a few more people to join.
Okay. Yeah, we're way early, so.
I know, I was like, oh, I was worried our presenter wasn't coming, but I just got confirmation, so I will be right back.
All right.
Hmm.
Hi.
Hello, how are you?
I am fine, thanks.
Let me get set up since we're using y'all's Zoom platform. Shouldn't take me too long.
Good morning, Britton. How are you? I'm Zareen. I've been
Good
emailing
morning.
is it
Yeah.
Megan or Megan?
Megan, yes, ma'am.
Nice to meet you.
Nice to meet you. Happy Friday.
Happy Friday. I know we have no one on yet, but I promise you they're coming. They're very excited for this
Okay.
class.
Well, I'm glad somebody is. It's not the most exciting stuff out there, but we'll make
Yes, that's probably fair. They're excited to be knowledgeable
that's good.
because it's, I think, a confusing topic for us.
It
Agreed.
is. It can be. All right, let me see. Can you see my screen?
Yes, that
Yes.
looks great.
Okay, good deal. Good deal.
So do you do teaching and underwriting or mostly
I
teaching?
do. Yes, I do. I teach and I do underwriting. So
All of it, huh?
a little bit of everything. I'm gonna pause for just a second. I need to go fill up my iced tea so I can stay awake.
Yes.
So I'll be right.
Fair
I think
enough.
I'm gonna do the same right here.
Yeah,
Yeah.
my coffee's sitting ready for me to go grab it.
All right. I'll
See you
be
in a
right
minute.
back.
I had this crazy dream and I don't really remember it, but you and Matt and Whitney were in it. So
Gosh, that's so funny. Causing trouble.
and we were like on some cruise and there was another little girl, Whitney's age. I don't really remember. It was very vague, but it was definitely y'all. So
That's so funny. That's funny because I had a dream about Katie Durkin the other night and her little girls who I've never met. I mean, obviously,
right.
but I had a dream where they were, it was so specific. They were wearing these cute little dresses, but one of them came up to me and she's like, I have dirt like all over, and it was so messy. So I was like, oh, I'll just cut this out for you. And I cut it like the Parent Trap style. And
Yeah.
then he was like, what did you do? Like, these are our dresses for family photos. And it was like, I haven't told her about it yet. I've not talked to her, but I will. So I was like, it's so, the things we think about and stress
I
about.
know. It's crazy.
Okay.
Here come the people.
Here they come. It's 10:30 now.
Yep.
All right, guys, welcome, welcome. We have our wonderful underwriters helping us out today and instructing us on the topic we all need to understand. There's a $10 payment that you need to make to them. It's not to me because I'm not the provider. I'm going to put the link in the chat. It's $10 to this link. Got to find the chat first. And then also, so that I can keep track of you, please put your name and license number in the chat. That's the only way I'm going to know who is here. So there we go. Okay, so you got to do two things to get the credit. Well, leave your video on, please. Put your name and license number in the chat, and then pay that link. And I'll post it again. I think if you join, you don't see the previous chat, so I'll probably repeat myself. So bear with me. Hi, Michelle. Hi, Madison. Hi, Brett. Hey, Bess. Hi.
Irene.
Welcome back.
All right. Yeah. Welcome.
Okay. We may give them one more minute. Just
Yeah, that's fine. Just whenever.
Okay, cool. Thank you. Get everyone situated. Self in there. Okay. Hey, Jackson. Hey, Jennifer.
Hello.
All right. So I'm going to put, to get CE credit, I need your name and license number in the chat, please. And we need to see your video. And then you're not paying me because I'm not the provider here. The provider is our wonderful, momentous underwriter, TRG in Britain. And so there is the payment link. I just put it in the chat.
I'm gonna have to hop halfway through. I just didn't want to miss the first part of this.
Yes, we have a lot to learn here. I'm excited for this. So good deal. Okay. Oh my gosh, Bess is coming in hot from Peru. You need to stick around after and tell us your stories. I want to see the pictures. All right, let's get going. Britton, whenever you're ready, you let me know.
I am ready.
Message people. Okay, perfect. Perfect. Great. All right. Okay. All right, guys, I'll if you're here for CE credit, I need your video, please. Put your name and license number in the chat. And there's a payment link. It's $10 that will go to TRG since they're the provider on this one, not me. And I think we're ready to get going. Before we sign off, I'll make sure I have a record of everyone who wants CE credit. Thanks.
All right, just whenever.
Yeah, take it away.
Ready? Okay, let me do one thing real quick. Let me close out my email so we're not getting email hits
Getting your pings.
while we are in doing that. And let me turn off my Teams calls and have those forwarded right quick so we don't have any interruptions. All right, sounds good. All right then. Well, welcome Friday morning to Unique Utilities for Realtors. I'm Britton Larson over in Tyler, Texas, from my farm or my home office. And we are going to talk a little bit about MUDs, SUDs, PIDs, and everything else that we encounter in our day-to-day contracts and what they mean and what we need to do. And I'll give you kind of the easy way to kind of bottle all this together. When we talk about disclosing, before we get into it, I'll just kind of, this is the way I kind of remember all this stuff. When we're talking about all these MUDs and PIDs and things like that, a lot of these assess fees, some even assess taxes like MUDs and the PIDs and things like that. And so the overall goal here is to disclose to the buyer exactly how much it's going to cost to own the property. So a buyer is not thinking, well, you know, it's only a $2,000 a month mortgage, I'll be able to pay it. And then they find out there's $600 in property owners association fees a month, or there's MUD taxes and MUD dues, or there is assessments from a public improvement district, and then they freak out. And somewhere down the line, some legislature's kid or somebody bought a piece of property and that happened to them. So we got all these laws and change. Maybe not that cynical, but the whole overarching goal here is to show the buyer exactly how much it's going to cost to own the property and to disclose that to the buyer. So if you think of that as kind of the overall scheme of things, I think it makes it easier to understand. And it's also analogous to something like a property owners association, right? We disclose that there are fees. So if you think about it like that, I think it makes it a little bit easier to understand your obligations and your seller's obligations. All right. Well, that being said, why do we talk about this? Well, our Texas Administrative Code, our real estate rules, we require that realtors be competent, and that means geographically competent in the area in which the services are being provided, as well as the types of property being brokered: residential, commercial, farm and ranch, commercial leasing, what have you. And different aspects of that geographic competency lead into these types of disclosures based upon what utilities are available in that geographic area, where the property is located, and whatnot. So it's your obligation as a license holder to be knowledgeable and competent as a real estate practitioner. The license holder must be informed on local market issues and conditions that affect the real estate in the geographic area where you provide services to a client, national, state, and local issues and developments in the real estate industry, judgment and skill in the performance of brokerage activities, and be educated in the characteristics involved in the specific type of real estate being brokered for others. So one of the times this comes up is if you're dealing with property that's outside of the city limits. I live in Tyler, but I'm not in the city. So I don't buy my water from the city of Tyler Water Utilities. I buy my water from a co-op, Southern Utilities. And so a lot of times you see these districts created that are outside of the city limits, such as a MUD that's providing water and sewage and things like that. When you're in the city itself, like if you're in the city of Dallas, you buy your water from the city of Dallas. You don't usually have to encounter a MUD, at least when I lived in Dallas. So that it really kind of depends on where the property is located and what's out there. So Texas Realtors provided guidance to license holders and said most buyers want to learn as much as possible about the properties they are considering. There's a wealth of publicly information available online that you can share with your clients. And specifically, they include water quality data in their list of publicly available information that can be shared with clients. There is a link for you there as far as the issue there that Texas Realtor Magazine back in May of 2020, when I'm sure you may have all read that, because in May of 2020, most of us were in our homes trying to read anything we could to stay awake when we were all on lockdown. But if you haven't, there's a reference for you as well. But the problem about utilities and information that are contained about utilities, you're both required to disclose, and a client may realistically expect their realtor to provide them. And that goes further than water quality, school districts, and traffic conditions. So when you're buying or selling property that's outside of an urban core, that's not in the city of Dallas, or that's not in, the city of Houston, Tyler, Austin, wherever, there are a dizzying array of entities that provide utility services to that property or may provide utility service to that property. Some of those entities have the ability to tax the landowner, while others have the policies, have the ability and the power to issue bonds. And selling properties located within those jurisdictions of some entities require mandatory disclosures by the seller, and some do not. And so it's a minefield for the unwary if you are not familiar with it. So hopefully we'll try to shed some light on it today. So MUDs, the MUD is the one we see probably the most. MUD is a municipal utility district. And I know this is a very jumbled slide, but there's a lot to cover, so I'll just kind of read the basic points. It's one of several types of special governmental entities that's authorized by the Texas Commission on Environmental Quality, and a MUD provides water, sewage, and other utility services within the geographic boundaries of that MUD. So there are maps that you can look at that show where the MUDs are. A MUD is created by adoption of a district creation bill by the Texas legislature or by the TCEQ following a petition and consent process described in the Texas Water Code. The Texas Water Code, I will just say, if you ever have trouble falling asleep at night, pick up the Texas Water Code and read a few bars of that, and you'll probably be out in about 5 or 10 minutes. There's not the most exciting stuff in the Texas Water Code. But the purpose of a MUD is to provide developers of the property an alternate way to finance infrastructure, such as water, sewer, drainage, and road facilities. MUDs are managed by a board that is elected by the property owners within the MUD. Developers may not appoint family members or employees to the MUD's board. So the MUD is managed by a board of property owners in the geographic area. MUDs are always, at least the way I see them, I can't say always because that's not exactly true, but most of the time they are created by the developers. But they can also be created by a majority of property owners in an area that petitions the TCEQ to create a MUD. But most of the time, you are going to see these being created by the developers of the subdivision that's outside the city limits or otherwise. The thing about MUDs is MUDs have the ability to issue bonds that reimburse a developer for authorized improvements, and the MUD will utilize the property tax revenues and the user fees that are received from the water and sewer services provided by the MUD to repay that bond debt. A MUD may also adopt and enforce necessary charges, taxes, and fees in order to provide those facilities and the services. So as in theory, as the MUD pays off its debt, its bond debt, more of its tax revenue can be directed to other services. So originally MUDs were limited in what they were allowed to finance and what services they could provide. However, some MUDs have been providing enhanced services for residents such as parks and recreation and open spaces and garbage collection and things like that. But originally MUD was designed to primarily provide water and sewer services. So what does it all mean to my buyer and what does it mean to me as a seller? So MUD taxes, the taxes that the MUD assesses are used to pay off the bonds that originally funded the MUD. As that debt decreases and the number of property owners in the area increases, the theory is that MUD taxes may, and may is underlined and in bold, may decrease over time. However, in addition, from your buyer standpoint, in addition to receiving a monthly bill from the MUD for their water and sewage services, they're also going to receive an annual tax bill from the MUD that makes that assessment. So that's kind of the double whammy there with the MUD. You're paying for your water and you're paying for your sewage, but you're also getting hit with the taxes that the MUD has the authority to level. For those of you that are accountants out there, if you itemize on your federal income tax return, you may be able to include your MUD tax bill as a deductible property tax, but I'm not a tax accountant or an attorney. So if you have questions with that, have your buyers talk to their CPAs. But that's basically what the MUD means for your buyer. They have the ability to issue bonds, but they also, not only are they charging you for the water and sewer services that you are using, they're also hitting you with a tax every year. So how do I find
I don't
out?
understand that. What does the tax cover?
Whatever the MUD assesses the tax for. The call primarily it's going to be used for the repayment of bonds.
Okay. So what
and
does the MUD go away when the bond is repaid? Like, how does that work?
Theoretically, no. They usually what happens is it really depends. I've seen it happen a couple of ways. The MUD usually doesn't go away once the bonds are repaid. The theory there is that the MUD can now use the tax revenue for other services, and costs may come down. The way I've seen it happen is usually what happens is the city grows and the city ends up annexing the land that the MUD is in. Then the city becomes the utility provider.
So basically the MUD is acting kind of like the city until the
kind
city.
of. It is a government. It's a quasi-governmental entity.
Okay.
The best example, where are y'all at geographically? Dallas, DFW, or y'all all over the place?
DFW for the most part, yeah.
For the most part, DFW. Okay, I lived in DFW for 16 years, so perfect. So y'all will understand my example. When I first moved to Dallas in 2022, I believe, when I left Tyler and moved to Dallas, no, I'm sorry, in 2020. Oh gosh, that's a long time ago. Any event, the whole point of that was when I moved to McKinney, Texas in 2002, Allen was cornfields. Now Allen is Cabela's and hockey rinks and everything else. I wish I would have bought land in in Collin County back then. But the whole point of that is, as when I was involved in this as a young lawyer, there were a couple of fights between like the city of Anna, the city of Melissa, and the North Collin Water Supply Corporation, and a couple of the MUDs. And those fights were over who's going to sell the water in that district. And so as those cities grew, McKinney, Anna, Allen, what have you, as those cities grew, they picked up some of that territory. And it was a big federal lawsuit stuff over who's got the right to be the monopoly on selling water in that district. And it's political and it's federal and it's a mess. And the USDA was involved. I was just a young litigator back then. But that's usually how you see it. The city will end up annexing either ETJ or something like that. But some of the MUDs can be around for a while. So they don't theoretically go away. Usually the way you see it is the city ends up annexing that area. So
Perfect. Thank you. Does anyone else have questions? Because I know what we want to like really understand what we're talking about here. So don't be shy. I'm sure if you have the question.
Yeah, and if I can't answer it, I'll tell you.
Okay, thank you. No, that helped me.
I used to do this water stuff when like I said, when I was a baby lawyer up in McKinney and Allen and all that. And I haven't touched on it so much in the legal side of it as much as I have now the disclosure side, since I got out of litigation and my blood pressure went down substantially.
Yeah, right. Okay.
Right?
Thank you.
Yeah, no worries. So how do I find out if my property's in a MUD? Well, the real easy way is look at your tax bill, right? Your county appraisal district bill, the CAD, is the MUD will be listed there on the property. So you may see McKinney ISD, North Collin Community College District, Collin County Hospital District, and then Brushy Creek MUD #1, right, listed there as taxing authorities. I just use Collin County as example because y'all are from up there, or y'all are in that area, and that's where I was familiar with. You also have a new centralized district directory, https://districtdirectory.org, that will show you an online site of where the MUDs are. And then finally, our Texas Commission on Environmental Quality website, a very good website for all things environmental, water, MUDs, SUDs, all that good stuff. So 3 ways you can find. I mean, the easiest way for me, look it up on the CAD or look on the tax certificate or the property tax bill. And your seller, ask your seller. I mean, your seller's going to probably know they've been paying. If they're in a MUD, who do you get your water from? Oh, we get it from the North Collin Water Supply Corporation or what have you. So whoever. How long is the delay between a MUD?
Oh yeah, that was going to ask.
How long is the delay between a MUD being created and appearing on a CAD? I don't know the answer to that question. I would assume if it's created by the legislature, when the effective date of that act creating that goes in, and then when they issue bonds and begin revenue. I would say the date of inception, but I'm not sure about that.
So as an agent, a lot of sellers are like, can be clueless or don't have a copy of their tax bill. Is the best practice just to go to this districtdirectory.org, and that should be
directory or Dallas CAD or Collin CAD or Parker CAD.
Okay.
CAD
It'll show on there as well.
Rockwall CAD. Yes, ma'am. It should.
I have a question about a specific area. Our agents do a lot in Highland Park and University Park, and there is a MUD. Like if you go, there is a MUD, but I think it's not, doesn't collect anymore. It doesn't show in the tax rolls. We're always wondering, do we need to show it? So do you know anything about that?
I do not, but I don't know how. I used to live. I never lived in Highland Park, but I have friends there. I lived over in. I was White Rock Lake trash. I lived on the other side of. I lived on East Dallas over by White Rock.
Me too.
So I didn't ever get over to the park, but I had friends there. I look at Highland Park and UP as kind of like cities within cities, right? Or towns within towns. I don't know whether Highland Park buys their water from the city of Dallas.
They do.
They do. So you get a city of Dallas water bill or you get a Highland Park water bill.
I don't know the answer to that, but Do you know that, if you go in, there is a mud, there is a
There
mud.
is a mud. Well,
But it's not, doesn't show on if you go to DCAT, it doesn't show it.
so it's inactive, or it's just
Yeah, I
something
think it's
that-
inactive.
If it's inactive and it doesn't assess taxes, and I don't know this for sure, but my thoughts would be, why do you have to disclose it?
Yeah,
It doesn't,
right.
it's not going to be created. That would be a situation where maybe the cities took over that mud.
Uh-huh. Okay.
And so, but if
And I
it's,
think most of our agents don't, but I think occasionally I'll get a question about it. So,
I mean, the alternative is
Right.
disclose anyway, so it doesn't,
Yeah.
but how would it come back and bite you there if there's no
Right.
way for them to
Yeah.
assess taxes?
Okay, thanks.
All right, so let's see. Water quality information, just in case you want to get the water quality information. If you do the MUD search, you can obtain water quality information by using that PWSID number, public water system ID number that is shown on the MUD search, and that can pull up your water quality systems. TCEQ general information on drinking water. They may also mail you something. I'm not really sure. I'm in a co-op out here because I live out in what used to be the country, but the city of Tyler's growing around us. But we get a disclosure every year from the people we get our water from that says this is how much lead and arsenic's in your drinking water or whatever, so I don't know if they send those out, but here's a way you can find out water quality information if you want to look at that. From the MUD search, you can find that number and pop it in there on those websites. All right, so let's talk about MUDs and why they're important. The Texas Water Code requires the notice to purchasers. And so in the section is district means a district that's either created under the local government code or created under this title by a special act of the legislature. And I'm not going to read all that law, but basically just says when we talk about MUD, this is the definition of what a MUD, municipal utility district is. And the big part for us is a person that proposes to sell or convey real property located inside that MUD has to give the purchaser the written notice. We do have a couple of exceptions where we don't have to give the MUD notice. Transfers under foreclosures, under lien foreclosures, a deed in lieu of foreclosure, a title by the will of an executor, probate proceedings. That's one you might encounter where the seller is an estate, or you're dealing with an independent executor or administrator. You don't really have to give a MUD in that situation. Most people do anyway, though, but you don't have to. Transfers of title to a governmental entity, like if you're deeding property to the city in lieu of condemnation or for whatever. Transfers of title for the purposes of qualifying a director. I have no idea what that one means. I don't have an example of that one. I would assume that would be a director of the MUD that has to own property in the area to serve on the board. But again, that's a new one for me. I don't really know. I don't really have an example of what number 5 would be. So the notice by the purchasers, or the notice to purchasers, shall be given to the prospective purchaser. And instead of reading all this legalese, I've put some bold in here so you can see the important part. Must be given to the notice. When do we give it? Prior to the execution of a binding contract and sale, either separately or as an addendum or a paragraph in the purchase contract. In the event that we do not give this notice, the purchaser can terminate the contract. However, if the seller furnishes the required notice at or prior to closing, and the purchaser closes anyway, even though it was not timely furnished, it's presumed that the purchaser waived the rights to terminate the contract and recover damages under this section. So we want to provide the notice there, and then the purchaser shall sign the notice or purchase contract, including such notice to evidence the receipt of notice. So if we don't give the notice, the buyer can terminate the contract. But if the notice is given late, and the buyer closes anyway, the buyer has waived basically the right to fuss about it for damages and the right to terminate the contract. Another notice here: at the closing of purchase and sale, a separate copy of the notice with current information shall be executed, acknowledged, and recorded in the deed record. So this is why we have to sign that second notice of MUD at closing. So we give the notice before we sign the contract or as an addendum with the contract, and then we sign this second MUD notice at closing and record it. And the reason we record it is because this law gives us a presumption that says we're entitled to rely on this MUD notice, that the information that the MUD district gave us is correct. And we're entitled to this presumption, and we can rely on this. And in case there are any errors, we're protected. We're allowed to rely on the information the MUD gives us. And this is my favorite part, and should be yours too. If we give this second notice and we record it, here's the fun part. The purchaser, their heirs, successors, or assigns shall not be entitled to maintain any action for damages against a seller, title insurance company, real estate brokers, or agents if this was filed correctly. In other words, they can't sue you. So if it's incorrect, so that's why we require this second thing to be filed, because it protects us all. We don't, if we do it right and we file it of record, they can't later come back on us. We relied on the MUD notice, we did it under statute, and we're protected here against lawsuits.
And so, Britton, who's preparing, who's responsible? Like, is it the title company's responsibility to know that that document needs to be signed at closing? And
I'm not sure who prepares it, if it's a junk doc, but it should be in the title package.
Okay.
I'm not sure who prepares
I'll find
it.
out, guys.
Usually it's a form, and they'll have the form. Usually the MUD prepares the form, or the MUD fills out the information and has the form. And then we have a copy of that we sign and execute at closing. So I don't think the title company's actually preparing it. I think they're more obtaining it, or somebody's obtaining it from the MUD to get that information. We don't have to do it. This doesn't have to do this, but we like to do it, because if we do it, well, number one, we said it's the remedy for not doing it is you potentially could be sued if there are any errors. So we file it as something to protect us all. If there is a suit for damages under this provision, in other words, if we did not file this and somebody got sued, has to be brought within 90 days after the purchaser gets their first tax notice, or within 4 years, whichever is first. So there's a statute of limitations there. All right, so that's our MUD. That's probably the one you're going to see the most. But we have a couple of other creatures out here that we need to look at. Water Control Improvement Districts, WCIDs. These are creatures that have broad authority to supply and store water for domestic, commercial, industrial use. They can operate sanitary systems, provide irrigation, drainage, and water quality services. A WCID is financed and operated almost exactly like a MUD is. Like a MUD, a WCID is overseen by the TCEQ and governed by a board of directors that is elected by the district residents. But although a MUD and a WCID can incur debts and levy taxes, they differ in the types of projects they can finance with those bonds and those taxes. MUDs, for example, can only finance the construction of non-existent water and sanitary sewer facilities, while water control improvement districts have the authority to purchase existing water facilities. Existing water facilities can be purchased by the WCID. All right, is there a promulgated form for the MUD disclosure? We have used the PID form in the past, but I'm not finding any form for MUD. There is not a TREC promulgated MUD form, but there is a MUD form that is available from the MUD itself. So contact the MUD and obtain the form from them and have them fill out and provide the information related to their tax rate and bonds. The MUD has to give you the district notice. They have to give you the proper notice. And if they charge you a fee, I think it can only be like a minimal fee. So the MUD has to give you the notice. So contact the MUD for that form. WCIDs are also created by Title IV of the Water Code. So why is that important? Because remember that disclosure we just talked about? That stuff we just talked about in MUDs? It's applicable to the WCID as well because they're defined in the Water Code as a district. So when we look at this definition, it's a MUD and it's a WCID that fall within this definition. So what does that mean? We have the same duty to disclose just like we had in a MUD. And so the exact same laws that we just talked about for the Water Control Improvement District are applicable to the MUD. We do the disclosure, then we do the second one at closing from the WCID, and we file that of record, and we are protected. No, PIDs are a different creature. We'll talk about PIDs in a minute. Let's see. Somebody says contact the MUDs early. Yes, do. If you're in a MUD, get that form. And some of them may even have it on their website. If they have websites, you may be able to find it on their websites. All right. So we have the same disclosure requirements with a water control improvement district that we do with the MUD. Districtdirectory.org. That's new. That has just come around maybe last legislative session where they required this to be placed online. So when I first started teaching this class, it was contact the MUD. Now I think the legislature has required the MUDs to provide these notices. And so we've got districtdirectory.org or to contact the WCID directly to see if a notice is required and get a copy of the correct notice to provide. The statute had like 3 different notices that you had to choose from. And it was really kind of, which notice do we give? Is it just in a MUD? Is it a MUD that's part of an ETJ? Is it a MUD that's part of a city? There were like 3 different notices we had to give. Now the law says they got to tell us which one is the correct one. The MUD has to tell us. So here's an example of one for the Upper Brushy Creek Water Control Improvement District in Williamson and Milam counties down there in the Austin area, Georgetown. You can see your property that you're about to buy is in the Water Control Improvement District. This is what our taxes are levied. Right now, we don't have any bonds issued, but we could issue them. Here's what the district is. If you don't pay, you're just being told that this is out there. These are charges that are going to affect this property. So there's an example of a Water Control Improvement District notice. How do I find out if my property's in a WCID? TCEQ website. Turn on the feature showing WCIDs. You can see the layers over here. TCEQ is a very good website. So if you got some time, spend some time on it. You can see water districts can be checked. Municipal districts, MUDs can be checked. Water control improvement districts can be checked. This is East Texas over in my part of the world. So you can see over here in Longview and Marshall, Gregg and Harrison counties, there's a MUD there. You get down to Nacogdoches. If you get down to Nacogdoches, you've got, sorry, they were in our district in high school when I went to Tyler High here, and they were in our football district. So we lovingly referred to them as Naca Nowhere. But anyway, Nacogdoches, good people down there. So if you get down there, you'll see there in some, and then down here toward Lufkin, and then all over the state. So this is available for all parts of the state. So you can tell from there. All right. MUDs, notice anything new in the Water Code 49-452? What we've got is we've amended district means district governed by 375 local government code, and a person who proposes to sell has to give that notice. So what is an MMD? It's a municipal management district, which is another type of district that we've got to look at. What is an MMD? It's an improvement district that's been used in the greater Houston area since the 1980s to allow commercial property owners to supplement city and county services and improvements. Property owners identify common problems and issues in their area and use the management district to implement solutions in those problems. So they're used in three distinct contexts: to support existing major activity centers, to promote neighborhood revitalization, and to support raw land development. And MMDs can provide water, sewer, flood control services like MUDs and WCIDs, but they can also provide a host of other services similar to that of PIDs. So think about an MMD is kind of like a combination between a MUD and a property owners association. They're not limited to providing just simply water and sewer. They can provide, a rec center for the area, or neighborhood revitalizations. You don't see these too often. I don't encounter a whole lot of these, but we handle the notice exactly like we handle the mud and water supply district. I mean, the water control improvement district notice. And again, they're listed at district directory. These have been used quite a lot down in Houston, greater Houston area. I don't know that you see many up in Dallas, but you might. They could be created at some point in time. Same thing that we do for MUDs and WCIDs. We can see them there on districtdirectory.com. If we have time, I'll try to pull up districtdirectory.com. Let's see. All right, here's our PIDs. Let's talk a little bit about PIDs. Public Improvement District. Here's the way I like to remember what a PID is. Think about a PID is almost like an HOA, except it's created by the city instead of the developer. Public Improvement District, property owners in a defined geographic area to jointly plan and put in place a sustainable funding source that can pay for a set of services to improve the area. They are created to provide additional services to the district supplemental to those provided by the city. So common services that could be shown by a PID: security, common area maintenance, sidewalk cleaning, minor capital improvements, beautification efforts, but can also include water service lines and sewer lines. PIDs are established through the local government, the city or the county, but are commonly managed by an outside third-party organization. So unlike MUDs, PIDs do not require the approval of the TCEQ or an act of the legislature, so they are not in the water code disclosures like MUDs and WCIDs. PIDs are created by the cities to serve areas inside their limits or within their extraterritorial jurisdiction, ETJ. But unlike MUDs, PIDs are repaid with assessments, not taxes. And assessments, unlike taxes, are supposed to end once the underlying bonds are repaid. So think about a PID is kind of like a property owners association in that it assesses basically fees and dues, but not taxing authority. But it does have the right to have a lien on the property, like an HOA, if you didn't pay your HOA dues. So you see these from time to time. It's kind of a new creature. We don't have any over here in the city of Tyler that I'm aware of, and the realtors that I deal with over here are not aware of any. But you do see them from time to time in some cities. So just be aware of those. Our disclosure for PIDs is going to be found in the Texas Property Code, not the Water Code. And the Property Code is a little bit more exciting reading than the Water Code if you have to read one. Property Code is effective September 1, 2021. So this just came out of the 87th legislature. A person that proposes to sell or otherwise convey property that's in a PID has to disclose. And this does not apply to our usual suspects. So we don't have to give a PID on a foreclosure sale, a sale out of bankruptcy, a mortgage, a foreclosure, a REO property, if you will, bank that foreclosed and took the property, deed in lieu of foreclosure, and then a fiduciary right? A administration of a dead person's estate. So an independent executor, a probate, sale out of probate from one co-owner to another co-owner of the undivided interest, to a spouse or person in the lineal line of consanguinity to seller, somebody that's in your first degree, your mama, your daddy, your brother, your wife, your husband, somebody that's in that first degree of consanguinity. To or from a governmental entity, if you're buying property from the state or selling property to the state, or if we're only talking about mineral interest transfers, a leasehold, a lease, or just taking a lien on the property. So I've sold a home buyer side and the PID was included on the tax bill in Hickory Creek. Okay, wow. Did they assess taxes though? Or were they just included listed? Because they shouldn't be assessing taxes unless something has changed. May have been listed as just an entity. I don't know that they should be assessing taxes, but anyway. All right, so what do we do on our PID? We do have a promulgated TREC form for this, right? 53-0, I believe, is our notice of property in a PID. So again, the bold stuff here, when do we provide it? Before the execution of a binding contract, purchase and sale, either separately or as an addendum or paragraph. In the event of a contract is entered into without the provided notice, the purchaser can terminate the contract. However, if the notice is provided late and the buyer elects to close anyway with the late notice, or if it was not furnished timely, then the buyer has waived the provisions of that disclosure. They can't try to terminate if they go ahead and close. Let's see, anything else? The purchaser has to sign it. Let me make sure I'm on the right page. The purchaser has to sign it and provide notice of evidence that it's receipt. So either the purchaser signs it or the contract that has the notice attached to it is signed by the seller showing receipt. All right, let's see here. Reliance on filed service plan. I'm going to hit the bold here. All sellers, title companies, real estate brokers, and examining attorneys, agent representative are entitled to rely on the accuracy of the service plan as last filed by the city or county in completing the notice to be executed, the PID notice. So whatever the service plan that will be filed or has been filed, the last one that's filed of record, we can rely on that conclusively when we are completing the notice to be executed by the seller. We can rely on that information and it's going to be presumed to be correct. And that means we can't get sued if it's incorrect. If the notice is given at closing, a purchaser or the purchaser's heirs assigns not entitled to come back and sue us, kind of like the MUD. So if we give the notice, we are basically protected as far as any issue that comes up because we use that notice or the information was incorrect or we relied on the legal description to determine whether the property was or was not in the MUD. So we are able to have some protection against that. All sellers, title insurance companies, real estate brokers, I put that in bold for y'all, are entitled to rely on the accuracy of the service plan that was last filed by the county or the city when we're filling out that notice. And for the purposes of the notice required, the information service plan filed in the county in effect as of January 1st of each year for the period January 1 to December 31. So what does all that legalese mean? It means we can rely on the information that the city has filed of public record in completing that notice. If that is incorrect, we cannot be sued because of it. And we includes title companies and you. So I see that somebody said, yeah, that's if the notice of PID is not given at closing, what repercussions does the buyer have at closing? Well, let's read it. In the event the sale and contract is entered into without the seller providing the notice, the seller's entitled, I mean, the buyer's entitled to terminate the contract. But if it's furnished at or before closing and the purchaser closes anyway, even though it was not timely furnished, the purchaser has waived. The question comes up, what if the notice was not given at all and they closed anyway? The answer is, I don't know. I think the answer would be that they are entitled to either damages or potentially to set aside the contract, but a court would have to determine that. And this is brand new law. And the reason I don't know is because it hasn't gone to court yet, and I don't know what the answer is on that. So if it's never given and it turns out that the property's in a PID, I would say that there could be damages, potential misrepresentation, knew or should have known, acts of omission, potential lawsuit. Would there be an argument there that, well, you closed anyway? Possibly, but the law doesn't give us an exception for not giving it. It gives us an exception for giving it late, and the buyer goes ahead and close anyway. So it's a potentially a lawsuit to set aside the deal or for damages or what have you, misrepresentation. And again, with this being brand new, I haven't seen a court decision on it yet, so I can't. I mean, that's what could happen. So make sure we give that notice. Again, as I said, we can rely on the filed service plan that the city has filed. Is this new? It's not really new. Prior to September 1 of 2021, this was in the contract. This was in the TREC contract. And the disclosure didn't say that the property was in a PID. It just said, if there's some things the buyer needs to be aware of. This was the old contract language that says you may be in a PID. If buyer, you need to investigate this. But the Texas legislature said that's not good enough. So what they did was they amended paragraph 7, beginning into all of our TREC contracts in September 21, 2 years ago. The seller needs to now know and disclose whether the property was located in a PID. See, I told you some legislature's kid got burned on this, right? I don't know that for a fact, but look at what they did. They took out all that language, and now it just says if the property's in a PID, seller has to give the notice as required. An addendum shall be attached to this contract. So TREC 53-0 is the addendum. So they put the onus on the seller now to know and disclose, whereby before it used to be, you may be in a PID, check it out, if you got any concerns. Again, that's what we've got. As of September 1, 2021, don't forget to check the box for the addendum and include that addendum. You can see that there is that check the box there added for the PID addendum. New PID notice, here we have it, 53-0. TREC gave us this new addendum. You can see what it says. You're buying this property, you're obligated to pay assessments to this PID for the benefit of this property created by the city or the county. This assessment's levied against your property. It's due and payable. You can get the exact amount from the city. You can find out the service plan from the city, and your failure to pay this assessment can result in penalties and interest and a lien and foreclosure of your property. So not unlike what we see with a property owners association. You're in an HOA. You've got mandatory dues. If you don't pay them, we can foreclose our lien. Not unlike the property owners association in that. That's how I like to think of these. They're like property owners associations that are created by the city or the county, usually by the city though. All right, SUDs. We're talking about water, so let's talk about SUDs. Here's the good thing about SUDs. Special utility districts provide water, wastewater, and firefighting services, but unlike MUDs or PIDs, they do not levy taxes. They cannot charge assessments. How does SUDs get their money? From selling water and providing the services that they provide, water, sewage, and things like that. The good news for you, there are no special disclosure requirements for properties that are located in a SUD, period, the end. So special utility districts, there's one south of Dallas I used to represent a long time ago, Rocket, SUD. It was Waxahachie area, kind of down Ellis County and Navarro County, kind of down in there. But that was a special utility district. There's a couple around that you see. No disclosures for those. They make their money by what they sell in water or what they charge for sewage. So no assessments or taxes. CCNs and CSNs. Do I need to be concerned about costs for getting water sewer service? So when we talk about CCNs and CSNs, we are talking about property that does not have water or utility service or sewer service installed yet. There's not pipes, there's not a meter out there. So sometimes we have to be concerned about this. A certificate of convenience and necessity grants a holder the exclusive right to provide retail water and sewer services in that geographic area. The Public Utility Commission of Texas grants these. The exclusive area that they now serve is called a CSN. Those of you that are my age or older, CSN to me means what? Crosby, Stills, and Nash. Come on, right? Yeah, that's what a CSN is, right? Anyway, but if you add a Y, you can put Neil Young on there too. But anyway, okay, I just dated myself to the 70s, but that's all right. So CSN, Certified Service Area or Network. So basically, this is a little mini monopoly, right? The government says that in this geographic area, only the such and such water company has the right to provide water in this area and the right to install lines and meters. So that's basically what we need. So chapter 13 of the water code provides the person that holds that little monopoly, if you will, over that area, they have to provide continuous and adequate water service to that area. Municipalities and districts, MUDs in city, like the city of Dallas, they usually don't have to have a CCN, but sometimes they do, especially some of the older ones. A district or municipality may not provide services within an area for which another entity holds a CCN unless they also have one for that area. So some type of overlap, and then water and sewer utilities are certified to provide services of various types of service areas. This is the lawsuit I was in up in McKinney all those years ago. The city of McKinney was trying to serve water, sell water in this area, and then the North Collin Water Supply was trying to serve water in this area, and they fought, right? But why are they fighting? Because that's a lot of revenue, right, coming from sale of water. So they fought, and eventually I think it was worked out or solved, because it's a little monopoly, right? You have that certificate. You're the only person that can sell water in that area unless there's an overlap with the city and there's agreements and all sorts of things like that. So why do we need to be concerned about this? It's listed in our disclosures in our paragraphs in our contracts. But remember, this is only effective if the property does not already have water or utility services to the property. So you can see we don't have to give this notice. We're supposed to give this notice if we are going to sell or convey real property located in that service area, but it doesn't apply to foreclosures, deeds in lieu, wills or probate transfers, governmental entities, transfer of title to property located within the corporate limits of a municipality that's served by the municipal owned utility, city of Dallas, right? A transfer of title to property that receives water or service from a utility on the date the property surveyed. So those two are the big exceptions, 5 and 6. The property already has water utilities. It's already getting water service from that provider. It's already getting water service from the city of Dallas because it's in the city limits, right? So these are the two big exceptions. This is why we don't usually give this notice on residential transactions that have water service. This comes into play a lot of times with vacant land or rural land or undeveloped land that does not yet have the infrastructure, pipelines and meters and whatnot to provide water to the property. And you can see the rest of the usual suspects there to which this doesn't apply. But these are the two big ones. So the notice has to be given. The real property area you're about to be in may not have water, and there's going to be charges to install lines and meters, and it's going to take time. That's basically what this says. You are invited to contact the provider, find out how much it's going to cost to get water out there, and that may be a substantial expense if they have to lay water pipelines and put in a meter or what have you, or they may have a pipeline out there. They may just have to put the meter in. You see this more with rural and vacant unimproved property than you obviously will with a platted residential subdivision that already has water. This has to be given before the execution of a binding purchase and contract and sale, separately or as an addendum. The purchaser signs the notice and sale contract that shows that they received a copy of it. All right, I don't. The rest of that's just legalese. It basically says the same thing. If we do this, if we give this notice and we file it of record, they can't come back and sue us. Let's see. Any purchaser that purchases real property and who subsequently sells or conveys the property is considered to have waived any previous rights to damages. So if you don't get this notice and you turn around and sell the property, you can't fuss about not getting the notice at the time you bought the property because you turned around and sold it to someone else. You can file a suit for damages if the seller fails to give this notice, but you've got to do it before the 90th day after you discover how much it's going to cost you to get water to the property and how long it's going to take to get it there, or by the first anniversary or by the fourth anniversary of which the property was purchased. So the earlier of. All right, let's see, what do we got? We moving right along here. We've got a little bit of finish to do here. Luckily for you, this notice is in the 1 to 4 family contract. It's also in the farm and ranch contract, right? So it's right there. This notice is provided. Hey, you may have to do this for a map of CSN's Public Utility Commission's website. There you go. There's where you can see it. But again, this is not something you're generally going to encounter that much unless you're selling a lot of vacant or undeveloped property or rural property that does not already have water or utility services. All right, groundwater conservation districts, real quick. Groundwater conservation districts have the authority to regulate wells and groundwater. Unpermitted and unexempt wells can be the subject of heavy fines for a property owner and even a subject of misrepresentation claims made against the seller. If any of y'all have taken Legal 2 recently, you're probably familiar with some of this. Texas Property Code 508 requires a seller to disclose if the property is located in a groundwater conservation district. You can see that on our TREC disclosure, on our TREC seller's disclosure. You can see it right there. Any portion of the property is located in a groundwater conservation district. Over here in Smith County, I am not in one. In Tyler, Dallas County is not in one. But if you get west and south of y'all and north of you, there are some. So just be careful about those, because we do need to disclose that on the seller's form. Where can you find out if you're in a groundwater conservation district? Right here, Texas Commission on Environmental Quality. Where are they? They're all over the place. And you may not be in your home county or the county that you do your work, but you may do some outside of county stuff. As of August 2023, this came directly from the TCEQ website. As of August 2023, here I am over here in Smith County, Tyler. We're not in one, right? But if you go down to Cherokee and around us and anywhere east of us, we are. Same with you guys in Dallas. Those of y'all that are in Dallas. Dallas, y'all aren't in one. Rockwall, Kaufman, Hunt, Van Zant, they're not in one. But you get up to Collin, Denton, you are. You get over into Tarrant or Parker, you are. And you get south of y'all down into Ellis or Hill or some of those, you are as well. So
then on the seller's disclosure, like our sellers in Tarrant County and Collin County should be checking like yes. And then is there anything additional we need to disclose?
Not if the answer is yes, please explain. I would say Tarrant region properties located in Tarrant Regional Groundwater District or what have you. And this is one of those weird things, like people are like, how am I supposed to know that?
Right.
I'm like, well, until I started teaching legal 2 years ago, I didn't know about it. I didn't know it was something you had to disclose either. But yeah, and it could be an issue because there could be unpermitted wells and exceptions, and each one of these groundwater districts have 101 different sets of rules. So, there's not one size fits all. But yeah, there's Tarrant County right there. All right, let's see the power. We're going to finish up and then I'll get your questions here. I've got a few more slides. The power to choose, not electric co-ops and city power. All right, so we're going to jump into electric here for a little bit. Texas legislature has enacted specific purposes and general statutes permitting the formation of co-ops by filing articles of incorporation with Secretary of State, including general co-ops for the business purposes of code, farmer co-ops, and the one we're going to talk about is number 3 here, electrical co-ops and corporations and telephone co-ops. As the name co-op implies, electric cooperatives are owned by their customers and profits are either reinvested or distributed among electricity consumers. So when Texas deregulated the electric utility market, it was made mandatory for investor-owned utilities, but optional for municipal utilities and electric co-ops. Municipal utilities and electric co-ops are both nonprofit organizations, and they can only become deregulated through a resolution. Their board of directors are governing body, and once they agree to deregulation, the process is irreversible. We don't really need to get into all that electric deregulation. Notable markets that do not have electric choice: Austin, Brownsville, Bryan, Burnett, College Station, Denton, Garland, Georgetown, Greenville, New Braunfels, San Marcos, San Antonio. For a list of Texas electric co-ops, you can see the member directory. Also, the service areas for AEP, SWEPCO, and Entergy Texas lack choice, even though these are private corporations. So you got to buy your energy from that energy provider. An example I had when I lived in Collin County, when I lived up in McKinney all those years ago, CoServe was my electric provider. Y'all heard of CoServe? That was an electric co-op up there in the North Collin County area when I was in McKinney. And you buy their electricity, and every year they'd send you a check for like $12 or something, which was your share of the profits. So yeah. Any event, that's a couple of things about electric co-op. The last thing we're going to talk about is propane. Propane gas service systems areas. Think about these as kind of like a MUD, except instead of providing water and sewage services, they're providing propane gas in their network and their facilities. So a distribution system. The good thing about propane gas systems areas is they have to file this in the public record. They've got to provide the service map, a copy of this, and they have to file this in the deed records. And then we have to attach a copy of that, or your seller has to attach a copy of that. If a person proposes to sell or convey real property located in a propane gas area, that the purchaser has to be given written notice that includes a copy of the notice that's recorded in the real property records, and has the language in here that says your property's in a propane gas service area. There may be special charges that you have to pay before you can get propane gas delivered to your property. It may take time to get lines there, not kind of unlike what we did with the property that didn't have water. We had to tell them, hey, it may take time to get gas out to your property and all that good stuff. We have a TREC form for this. Why? I do not know, but we do. We have 47-0. Don't forget to read it and comply. Addendum for property located in a propane gas system service area. The notice has to include a copy of the notice that is filed of record. A copy of the recorded notice is attached. Yes, does a property note copy of propane notice count in addition to TREC form? It's whatever it's the notice of disclosure. It's what they file in the real property record. So it's very limited. I don't know if the contract where you're going to buy the propane is not what we're talking about here. This is but when you contract to buy the propane, they may send you a copy of the notice. But what we're talking about is a document that they file in the real property records that shows, hey, this is a propane gas service system area, and the notice has a service map, chapter of the customer's rights, copy of this chapter, and a statement disclosing the interest of any financial interest held by an HOA or MUD or developer in that propane gas service system areas. Okay. Now, the good news for you is most of you are never going to encounter this unless you are down in Travis County. However, there are a couple in North Texas that you might need to be aware of. There's one over at Eagle Mountain Lake in Tarrant County. And then if you get a little further west to Hill Country Harbor in Palo Pinto County, there's a couple. Now, that doesn't mean they can't be created at any time, but for most of us, these are going to be seen down in the Austin, Travis County area. But there are two that we are aware of. You can find these with the Railroad Commission's website because they regulate oil and gas in Texas. And are the rates regulated? No, but we do have price caps that are set by the TRCC, the Texas Railroad Commission. All right, so right at an hour of instruction there from when we got started. Let me look at a couple of things encountered in Bonham. They are filling new lakes, so limiting water meters for vacant land. Municipality would not authorize water meters. Could not divide into 10-acre lots, would have to share a meter. No new wells allow. Yep. So, I mean, and I don't know if that, I've been hearing they were going to build a lake up in Fannin and Bonham counties forever. Did that ever go through? It did. What was it going to
Yeah,
call?
it's called Lake Bodark, I think.
Oh, Lake Bodark. Yeah. Well,
Yeah.
And when again, in a million years ago, when I was a baby lawyer up in McKinney, I represented Bodark Water Supply Corporation, Bodark Mud. Or I guess if I really wanted my French to be correct, I'd say Bois d'Arc.
That's
But
right.
in any event, Bodark, for those of y'all that don't know what us in East Texas are talking about. But yeah, I had heard that was going in forever. And I didn't know if it had finally passed or not. Is that like late?
They're in the process, I think, of filling it. I know they're starting to sell. I haven't been up there, but I've heard that. So
Dallas is getting thirsty, needs some more water. Well, hopefully they don't mess with things too much. But anyway, so yeah, talk to your groundwater conservation districts when you're dealing with the lady that's talked about these. If your developer's buying raw land or vacant land, or you're thinking about purchasing a lot, I mean, you've got to consider that. Because they may ask you, we're buying a place out in the country. Can we drill a water well? Well, it depends. Go talk to the groundwater conservation district because they may have rules and regulations. Yeah. Okay. So was this? No, the seller was an investor, so no sales disclosure. Learned about the legal too. Yeah, right. Legal too. I teach that. Not sure was sales in July. There was a well on the property. I mean, if there's a well on the property and the well's properly permitted, it may not be a bad issue. The issue comes up with is the well drilled without proper permitting, and it could be fine. The other issue comes up is the well. Are there any defects in the well, like permitting being unlicensed? I'll give you, if y'all need to drop off, go ahead. I'll give you an example here personally for me. My house has 3 water wells, 1 in the backyard, 2 in the front yard. They have not worked since Leonard Skinner was together in their original form. They haven't worked since the late 70s, but they're still out here. And when we had new septic put in 2 years ago, we had to re-diagram it around those water wells. And I told the guys, it was like, there's no way those water wells have not worked, but they could work. You could go in and rework them. And so that would be an issue where if I were to sell my house, I would put on the disclosure. There are 3 water wells out here that do not work and may not be currently permitted for reworking. If you put a pump and electricity and piping and all that, and it may be too darn close to the leach field. of the septic tank because we just don't use those wells anymore. So because we have city water, but if the wells are in working order and they were properly permitted, it may not have been an issue. But yeah, that's why the Trek started stressing this in Legal 2 years ago when I started teaching it, that this water stuff's really, really important. So, all right. We have a property in Trinity Valley Electric Co-op now. It's disclosed on this SDN. Do we need? I don't know of any specific electric co-op disclosure that's required, but I would definitely disclose it in the seller's disclosure. But I'm not aware of a freestanding electric co-op because they don't assess taxes. You're just buying your electric from them, just like you buy your electric from TXU or wherever. You just don't have a choice in that situation to go with Encore or TXU or whomever shows up at your door and tells you they can get you a better rate. So anyway, all right, good times. I'll turn it back over to y'all. Thank y'all for being on this morning. Y'all have a great weekend. And if you're over in the city of Tyler, I will give myself a shameless plug. I'm doing Driving Miss Daisy on the theater stage this weekend. So if you find yourself over in East Texas and you want to stop by, let me know. Come see me. Other than that, y'all have a great time and y'all have a great weekend. We'll see y'all later.
Thank you.
Y'all.